Good evening. Is this on? Good evening. Oh. Hello, everyone. My name is Jennifer Dinitz, and I'm the president-elect of the Florida Association for Women Lawyers of the Palm Beach County. FAU is a voluntary bar organization that promotes gender equality in the legal profession and strives to maintain the highest levels of integrity, honor, and courtesy in our legal careers. Thank you to Professor Tunick and FAU for welcoming us today. We are honored to be able to provide you with a presentation and panel discussion this evening in celebration of Constitution Day. Tori Whalen has worked extremely hard to take this event to the next level for us. We have an esteemed group of judiciary and attorneys from the 15th Circuit joining Professor Tunick today. We encourage you to ask questions and participate when the panelists invite you to at the end of the program. Attorneys will receive 1 CLE credit for today. And without further ado, I give you Tori Whalen of the Law Offices of Day Pitney to start our presentation.
Thank you very much, Jen, and thank you to Palm Beach County FAU as well as FAU and our panelists for volunteering their time tonight. Constitution Day is celebrated on September 17th, and it commemorates the day that the U.S. Constitution was signed in 1787. The U.S. Constitution is unique in that it has governed as the supreme law of the land for the past 236 years, yet it is still being interpreted daily. As those famous first 3 words remind us, we the people have a duty not only to abide by the Constitution, but also to uphold it. Tonight's panelist presentation focuses on this duty through a discussion of judicial decision-making and voting rights. I would like to begin by introducing our panelists. First, we have Professor Mark Tunick. Dr. Tunick teaches political theory and constitutional law at FAU's Honors College. He received his bachelor's degree in political science and management from MIT and his PhD in political science from UC Berkeley. He then taught at Stanford University before becoming one of the founding faculty of the Honors College in 1998. He has published numerous books and articles on topics including privacy, punishment, property takings, religious toleration, and the political philosophies of John Locke and John Stuart Mill. Next, we have Judge Samantha Fuhr. Judge Fuhr is a native Floridian, attended Tufts University and the University of Florida Law School. Upon her return to South Florida, she advocated for victims of violent crime as a prosecutor. She then served as the South Florida Bureau Chief of the Economic Crime Unit at the Florida Attorney General's Office. Prior to taking the bench, Judge Fuhr was a commercial litigator at Ackerman LLP, handling civil prosecutions of insurance fraud. In 2014, she was elected circuit judge for the 15th Judicial Circuit and now provides in the probate division. Judge Fuhr is also an active member of her community. She founded the Women's Foundation of the Palm Beach County, where she started the Girls Leadership Institute in the Road to the Bench program. She has also served as president of Palm Beach County FAU and currently serves as the FAU Judicial Liaison and has earned numerous accolades. Panelist Amy Borman is the Chief Legal Officer and Chief Operating Officer for the courts and official records at the Clerk of the Circuit Court and Comptroller's Office for Palm Beach County. Ms. Borman joined the clerk's office in August 2019 as the Director of Branch Court Services and was promoted to COO in January 21 and to Chief Legal Officer in January 2022. Prior to joining the clerk's office, she was the general counsel to the 15th Judicial Circuit of Florida, where she served as the attorney to the judiciary and oversaw the law clerk and summer intern programs. Ms. Borman is also an adjunct professor at various law schools, as well as this honors college, and she serves on various committees for the Florida Bar. Panelist Judge Charles Burton was appointed as a county court judge in May 2000, as a circuit judge in November 2005, and is currently the administrative judge in the probate division in Delray Beach. He has previously served in the civil, criminal, mental health, drug court, family, and probate divisions. Prior to taking the bench, he was an assistant state attorney in Palm Beach County for 11 years and was in private practice for 5 years. As an assistant state attorney, he was chief of the Crimes Against Children Division, and as a prosecutor, he had tried more than 200 felony cases. Shortly after being appointed to the bench in 2000, he served as chairman of the Palm Beach County Canvassing Board during the Bush-Gore presidential election and recount. Next, we have Judge Ashley Zuckerman. Judge Zuckerman began her legal career at the Public Defender's Office in Palm Beach County after graduating law school from Nova Southeastern University. While a practicing attorney, she tried over 80 trials to verdict and spent time as a supervisor training new attorneys. She was elected to the bench in November of 2018 as Palm Beach County Court Judge. Currently, she is assigned to the criminal courtroom, where she is the administrative judge for the County Criminal Division. She is also the administrative judge for the Traffic Division. She is actively involved in Palm Beach County Bar Association, including as a member of both the Judicial Relations Committee and the Professionalism Committee. Judge Zuckerman is the court liaison to the Probation Advisory Board and the Public Safety Coordinating Council, and also volunteers with the Riviera Beach Civil Drug Court. Lastly, we have panelist Judge Danielle Sharif. Originally from Queens, New York, Judge Sharif earned her Juris Doctor from Florida State College of Law and her Bachelor of Science in Criminal Justice with a minor in Political Science from Florida International University. Judge Sharif was appointed to the County Court Bench in Palm Beach County in May 2023 and is assigned to the Civil Division. Prior to her appointment, Judge Sharif was an attorney for the School District of Palm Beach County and was a personal injury attorney with Lesser, Landy, and Smith, and was also an assistant state attorney in the Palm Beach County for over 13 years. While at the state attorney's office, she was chief of the Traffic Homicide Unit. Judge Sharif has served her community as a past president of Palm Beach County Fall and president of the F. Malcolm Cunningham Senior Bar Association. She also speaks with and mentors both high school and law school students, and she has served on several boards. Once again, I want to give our panelists a huge thank you for being here tonight and volunteering your time. After we conclude the presentation, there will be a question and answer session, and I encourage you to take advantage of the opportunity to ask the panelists any questions you may have. I will now turn it over to Dr. Tunick, who will begin the presentation by speaking about the Constitution and the separation of powers.
Thank you. The attorneys and judges who are in the audience for making this extraordinary opportunity available to our students. So before there was a Constitution, and you can go to 2 slides from there. Before there was a Constitution, there were 13 states, and they were loosely assembled as a confederacy, and there was really no strong central government. So each state could coin its own money. Each state could set up importations could tax imports from other states. And because of this lack of power, there were a lot of inefficiencies. There was a possibility of trade wars. So they agreed to get together and constitute a new government that did not exist before. And that's what the Constitution is, where the states agree to give up some of their powers and create a new federal government that did not exist before. And the key idea is that the Constitution is like a rule book. Congress cannot do anything it wants. A lot of people don't appreciate this. Congress cannot just say, I think it's a good idea to have a law, and so if we get the votes, we'll do it. The barrier is not just whether they can get the votes, but they have to be able to point to some provision in the Constitution that authorizes them to enact what they want to do. The president, same thing. So during the Korean War, President Truman was worried about steel workers going on strike. And so he issued an executive order basically taking over the steel mills to ensure that there's a supply of steel. But there's nothing in the Constitution that clearly authorized the president to do that. And the Supreme Court said, no, this is something that's left for Congress. So again, the Constitution is like a rule book saying what can and can't be done by this new federal government. And of course, it also sets up the federal court system. So next slide. The legislative, executive, and judicial branch. Next slide. So a crucial feature of the Constitution is that it sets up these 3 branches of government, but it gives them co-equal powers so that there's a sort of separation and check from each branch. And what I want to focus on is the role of the courts, because today we have judges and attorneys on the panel, and we're going to talk about the role of the judiciary in our constitutional system of government. Some people are concerned about the Supreme Court and its power to strike down laws because no one elects the Supreme Court. No one elects the justices. There was a case that some of you are aware of a few years ago, Obergefell versus Hodges, in which some states felt that same-sex marriage should not be permitted or sanctioned by the state. And some people challenged these state laws, saying that they should have a right to marry who they want, and that not letting them do this violates the equal protection of the law and their liberty interests. And it went to the Supreme Court. And Justice Scalia, the court struck down these state laws and did declare a right for same-sex marriage. Justice Scalia dissented, and he argued that These are states where the majority of people in these states felt that same-sex marriage should not be permitted. Who are we as a Supreme Court to strike down the will of the majority? None of the 9 justices at the time were Protestants or evangelical Christians. They all went to Harvard and Yale. They do not represent the will of the people. And the point I want to make, and this is the last point before we turn to the next panelists, is that the idea that the judicial branch can check the will of the majority is part of the brilliance of the Constitution. It might seem like it's going against the will of the majority. But the Constitution, which is a democratic form of government, is in some ways anti-majoritarian, because democracy is not just about abiding by the will of the majority. If you look up the word democracy in a dictionary, it will say rule by the majority. But it will also say respect of each member of the political unit, respect for minority rights. Now, respecting minority rights is part of what democracy means. So is going by the rule of the majority. So we have 2 definitions of democracy that are in conflict. And our Constitution recognizes this by having a judicial branch who are not elected and therefore not subject to the whims of the population. They don't have to read public opinion polls. And they set limits on what a majority can do. It's anti-majoritarian, but that's part of democracy. The court provides a check against what some people call the tyranny of the majority in order to protect democracy. And this leads me to transition to the rest of our panelists, because they're going to talk about the crucial role of judges in our constitutional system of government.
Thank you, Dr. Tunick. We are now going to use that to segue into judicial decision-making. Please turn your attention to Ms. Borman.
Okay, so if you can go to the next slide, or my slides. So we're going to talk about judicial decision-making and the judicial branch and the role of the judicial branch. And as Dr. Tunick said, and as you learned probably in your 7th grade civics class, you have the 3 branches of government. You have the legislative branch that makes the laws, you have the executive branch that enforces it, and then you have the judicial branch that interprets it. And what does that mean? Because it's very easy to understand making a law. Okay, so we have a councilman in our presence right now, and they make laws for the, sorry, Michael, for the village of Wellington. And that's the legislative branch. And then the police officers who are enforcing it, and the state attorneys, and a lot of our judges have been state attorneys, they're enforcing it. And then the judges go to interpret it. And I've always found when I teach, that is one of the hardest things to explain, is what does it mean to interpret the law, right? So it's sort of this vague, nebulous thing. So there are the differences with the judicial branch than the other branches. It is supposed to be, as Dr. Tunick said, insulated from pressure, right? Whether it's the media, whether it's political interests, it is supposed to be insulated. And there are different ways of becoming a judge. And as in the intro, Judge Fuhr was and is on the committee on the road to the bench. How do you get to be a judge? There are judges whom are elected. There are judges whom are appointed. It depends on which state you are in. It depends if you're in the federal government or the state government. But what they try to do is create a system, and no system is perfect, because if you're elected, you have people donating to you. If you're appointed, is it the will of the person who's appointing you? But they try to do it so that it's done in a way that you can rule and be insulated from that political pressure, because what you're doing is you're ruling on whether it's the constitutionality of a matter, if it's litigation. So when you look at, and I always think about, when you think about the law, you think about the scales of justice, and you'll see usually the Lady Liberty, and she's holding her scales. What's around her eyes? It's a blindfold. That's okay. Is that Siri answering me? So there's that blindfold because you're not supposed to see those other things. So if I can bother you for the next slide. So in the judicial branch, and it depends on what level you are in the next slide, and I'm not keeping track of my time, so I apologize. So just let me know how I'm doing. There are different roles. So you have the trial court where you're resolving disputes. You have somebody that's filing a lawsuit. It could be a civil case where you have a plaintiff and then a defendant. It could be a family case where you have a petitioner and a respondent. And the judge is asked to decide matters dealing with money or dealing with property or dealing with children. Judges also are asked to interpret the law. And that's what I said on the last slide. What does that mean? And the example I like to give, and I usually do this when I'm teaching third graders, but I think to me it's a very easy way of explaining it. If somebody were to say to you, there's no vehicles in the park, right? There's no vehicles in the Jupiter Park. What does that mean? Should a sanitation driver get a ticket for driving in the park? Or if you're in the parking lot, is that driving in the park? If you're driving your bike, is that driving in the park? And everybody gets ticketed, but who actually is guilty of driving in the park? So the judge has to interpret that law. What does that mean? What was the legislative, going to the other branch, their intent? Was it to basically be you or I driving through the park? Was it really meant to stop a sanitation worker from driving through the park to pick up the garbage? So that's interpreting the law. They're determining whether the law is unconstitutional. So there was a recent decision with regard to a law that was passed locally on there's no panhandling. But are you only saying no panhandling of the homeless? What about the Boy Scouts that may be out in the median of the street asking for money? Or what about somebody asking about the car wash or the football team? Are you only targeting the speech or the actions of those who are doing it because they're homeless? So you're determining that statute, is it constitutional or not? Is it infringing upon one group of people over another? And then you're also safeguarding the Constitution. So you want to make sure that people have a right to an attorney. You don't want to have any laws that are passed where somebody who's arrested, everybody knows the Miranda rights, you hear it, you watch it on all of the TV shows, you have the right to remain silent, anything you say will be used against you. We have a right and an obligation to protect those constitutional rights. So that's the other option, the other role of the judge. Next slide, please. So the last thing I just want to talk about is a different court system. You have our state court system and you have our federal court system. So you start at the lowest level, I should say that the largest level is our county courts, and it can be both criminal and civil. And usually for criminal, it's the cases that are minor, like the misdemeanors or the criminal traffic cases. You also have civil cases that are based upon the monetary amount. For years, it was $15,000. They finally raised the limit to $50,000. When you go to the next level up, you're looking at not just the felonies and the cases greater than $50,000, but certain specialty areas like probate, where Judge Feer and Judge Burton sit, family law cases, juvenile cases. Those are solely within the authority of a circuit judge. And then you have the appellate court. We just got a 6th District Court of Appeal, and that's where you have one right of an automatic appeal. And then you have the Supreme Court of Florida. So everybody says, I'm going to take it to the Supreme Court. You don't always have that right. So it's that second tier of appellate review. In the federal system, there are 3 levels. You have the district court, which is your trial court. So that's the flip name. In the state system, our district court is our appellate court. In the trial court, the district court, in the federal system, the district court is the trial court. So Judge Reinhardt is in the trial court of the federal system. Just want to call you out as well. Then we have the appellate court, and that goes, and again, you're looking federally, so we're in the 11th Circuit, so you're looking at Georgia, Alabama, and Florida, all are within the 11th Circuit Court of Appeals, and then, of course, you have the U.S. Supreme Court. So that's sort of looking at the difference between a state court and a federal court, and sometimes you have that direct way of going from the state into the Supreme Court, but very, very rarely. So with that, I think I'm done, and I'd like to turn it over to Judge Zuckerman.
All right, I have to tell you first. Tori, thank you so much for everything you've done to put this together. And Fall, thank you so much for having me. I love being at events like this. It makes me so happy. Speaking of happy, the picture that you all saw in the introductions, right? You saw the picture of all of us, right? My picture was taken the day of my 35th birthday. It was 2 weeks after I had just been elected judge, and nobody has ever been happier than I was in that picture. Every time I see that picture, I laugh, because I think when people come into my courtroom, it's not the same face as my happy face for my official picture. Anyways, all right, well, I'll start off. I have a fun fact. I love fun facts. I want to tell you all, since we are here for fall and on Constitution Day, it sounded like such a good fun fact. On this day in history, in 1893, New Zealand became the first country to give women the right to vote in national elections. Isn't that amazing? Today.
September 19th in 1893. The U.S. wasn't until 1920 with the 19th Amendment. We followed much later, but New Zealand was the very first country, recognized as a country at that point, to give women the right to vote in a national election. So there's your fun fact. Okay.
That was a good fun fact.
Thank you. I thought so too. Also, everything I'm going to speak about is very general. We often have to speak in general, kind of broad, conclusive statements. So I want to apologize for that. I am happy to answer any questions. I know the rest of the panelists are as well. Speaking of broad statements, when women received the right to vote in the United States in 1920, it was not all women. There are specific groups, portions of the population that did not. So that was a very broad statement. You will hear many more from me, just a warning. All right, let's get to work. How judges make decisions. Well, we sort of talked about it a little bit earlier with the other panelists in that there is often a political opinion or a public opinion that could sway an individual when faced with certain decisions. Judges have the unique responsibility of not letting that factor in. And it is not an easy task, but it is an essential task. So for example, I sit in the county criminal division, meaning that there are misdemeanors in front of me and criminal traffic infractions. So the misdemeanors are often trespass cases, driving under the influence cases, things like that. Misdemeanors, so their punishment is under a year. There are also many firearm cases. In Florida, there has been a lot of legislative action regarding firearms, and it often comes with a lot of political opinion, public viewpoints. People feel very strongly about certain matters with firearms. And so that is an example of a type of case that comes in front of a judge in county criminal, in other divisions as well. I'm just using myself as an example. And it may carry with it a tremendous amount of public policy or political viewpoints. That is something that is not taken into consideration. It cannot be. It is an essential function for a judge to be able to put that aside and rule on the facts that have been presented. Now, speaking of that, I want to try and break it down a little bit. When an individual is charged, and Tori, please tell me if I go over. When an individual is charged with a crime by the state of Florida, they are charged by violating a certain statute. Oftentimes, by looking at that statute, the Florida statute, it can give you the definitions, right? It can give you possible penalties. It could be very clear. It could, as Ms. Borman stated, become something that needs to be interpreted. For example, who can be driving, right? What type of park is it? Are there exceptions? So for one of the firearm cases that I was talking about, there is a statute regarding a display of a firearm. And the statute has language such as rude or careless or threatening behavior with a firearm, right? So something like the word rude, how does someone rudely hold a firearm, right? This is a question that is not answered by the statute. So what a lot of times would then become the next step is to look at what's called stare decisis, which is the case law that has been developed by other courts in prior decisions. And so that way you can kind of break down what you need to look at. For example, what has been held to be rude before, right? If someone is just walking down the street and swinging their arm, is that necessarily rude or is that necessarily threatening? So that's kind of the breakdown. I wanted to maybe give you an example of how that kind of happens. I think we can go to the next slide too. Thank you. So the Constitution, as Dr. Tunick stated, is really the backbone, the rule book of laws. And there, as you all know, sounds silly to say, I know you know this, there is the United States Constitution and there's the state constitution, right? Oftentimes state constitutions provide more protections because they cannot provide less protection. So the state constitution and all of these statutes are still within this rule book of the United States Constitution. But when we talked about earlier, when I said that there were certain, for example, a gun charge where the statute says something like the behavior is rude or careless and needs interpretation, that can apply as well to the Constitution. So for example, there may be something straightforward in the Constitution. There is something straightforward in the Constitution about the number of senators from each state, right? There are 2. Pretty straightforward for the most part. There is also language in the Constitution that requires interpretation. For example, on the slide, as you see, what is cruel and unusual punishment? And there is a lot of case law and prior decisions, stare decisis that we talked about previously, that would enable a judge to go back and look at past decisions and kind of break down and interpret. So when you talk about interpreting the Constitution or a statute, it's not necessarily how the judge thinks or what the attorneys are arguing. When you're looking at interpretation, you're often going back to other decisions or other courts to see what the prior courts have held for the interpretation. Does that make sense? Are you all still with me? Yes? Okay, I feel like I'm talking to you. I see you back there, Len. All right, I don't want to go over my time, so let's go to the next slide, and I'll talk a little bit about jury trials because they're so fun. So jury trials are very common in county criminal court. I do usually about 1 a week, sometimes more, sometimes less, depending on how things work out. But when an individual is charged with a crime, and this is very general, usually they have the right to a jury trial. They can sometimes waive that right to their jury trial and ask to go only in front of the judge, whereby the judge becomes the fact finder, right? And it's sort of, I think, what people think about when you think about a judge. You're determining the facts, right? You're ruling on things. When you bring in the jury for a jury trial, the judge really acts as a sort of guide, gives them the law. But it's the jury who is going to decide the verdict. So 6 individuals are going to come in, they are going to sit down, they are going to listen to the facts, and although I may read them the law and I may be able to answer certain questions, it is the jury that goes into the back and sits and decides a case. And while I have the pulpit, I have to do this. I have to tell you all that jury service is very often denigrated in that everyone's trying to get out of jury service, right? You've all heard it. I know you have. I hear it all the time. My friends, how can I get out of jury service? And then they get the lecture I'm about to give you, which is that jury service is really one of the very few things that our country asks of us. Really, when you think about it, it is one of the very few things that we are asked to do in this country. And what it does is so essential. It enables individuals to have a jury of their peers as they are entitled to, as our laws say that they are entitled to, because think about it. If none of the jurors are showing up, if everyone's trying to get out of jury service and no one ever comes, how do they have the criminal trial for the individual to try and proclaim their innocence, right? How does the civil case go forward without a jury when there's a business dispute? So I think everybody, it's one of those things where you kind of think everyone else will do it, right? People try to get out of it so often. It really is not so bad. I will tell you that the majority of jurors at the end of the trial have told me this really wasn't so bad. In fact, I enjoyed it. I'm not going to promise you that you're going to enjoy jury service if you're picked. I am going to tell you it really isn't as bad as this whole misconception that we have in our head, and it really is one of the very few things that we're asked to do. I would encourage you, if you are summoned for jury service, as one day you will be, to show up for your jury service and report. And really, it is, I think, oftentimes a very enlightening process. The county criminal trials that I do take 1 to 2 days. Right? You're not going to be there for weeks, not in a county criminal case. They're 1 to 2 days. And you've really fulfilled one of, like I said so many times, the very few things that our country asks of us. So I will just end by saying, don't try and get out of jury service. Thank you.
Thank you, Judge Zuckerman. We're now going to pass it along to Judge Sharif, who will be talking a little bit about some constitutional cases.
Hello, everyone. I don't have a fun fact, but tomorrow will make 3 months since I've been on the bench, so I'm one of the newer judges in our circuit. and my picture was taken 1 week after I was appointed, so I was still on my high. And what I've learned in the 3 months since I've been on the bench and what I knew what I was getting into is that judges have to make difficult decisions every day. And I was told by a judge, if you're making decisions and you're making everybody happy, then you're not doing something right. But when we're making these decisions, our decisions must be in accordance with the Constitution. And oftentimes, those decisions aren't always popular. Next slide, please. So, I don't know if you guys are familiar with the Supreme Court case Brown versus the Board of Education. It was decided back in 1954. And that case, at the time that case was decided, the law of the land was still separate but equal. Back in 1896, there was a case, Plessy v. Ferguson, which was decided by the U.S. Supreme Court that said that as long as facilities were equal, that separate but equal was constitutional. As we know, at that time, although they were separate, they were definitely not equal. 17 southern and border states, along with the District of Columbia, required that public schools be racially segregated. At that time, the attorney who represented Brown was Supreme Court Justice Thurgood Marshall, and he argued on behalf of Brown. And so the court, in a unanimous opinion, concluded that the field of public education doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated are deprived of equal protection of the laws guaranteed by the 14th Amendment. So, of course, separate but equal was unconstitutional as it violated the 14th Amendment. But at that time, if you can imagine, this was during the height of the civil rights era. And so although these 9 white male justices, ruled that separate but equal was unconstitutional, you can imagine that at the time, there may have been huge public opinion that did not agree with that ruling. And if you would go on to the next slide, please. Okay. So Earl Warren was the Chief Justice of the U.S. Supreme Court at that time, and he was a justice, I believe, from 1953 to 1969. So during that time, you can imagine the cases that came before the court. But in ruling that separate but equal was unconstitutional, of course, there was a public outcry. There were protests, and they wanted to impeach Justice Warren. And at that time, and still today, to impeach a federal officer, there are three things. It's either for treason, bribery, or high crimes and misdemeanors. So, of course, there was outcry and outrage, and obviously he was not impeached. But if you just think back to that time, and even today, judges, if you were to let public opinion play into your decisions, how would that affect the public? And I can tell you, when I was going through my appointment process, I was appointed, I was not elected, meaning that I had to go through several interviews, and one of my interviews was with the governor's office. And that's a question that they ask us. As a judge, when you're making decisions, are you going to let public opinion affect how you would rule? Are you going to decide a case one way or another, worried about, well, if I decide for one party versus the next, what are they going to say? What are my friends going to say? What are people at my church? And these are questions that judges have to deal with on a daily basis. Next slide, please. This is another Supreme Court case. This is Texas v. Johnson, and this was decided back in 1989. The respondent, Gregory Lee Johnson, he was protesting in 1984 at the Republican Convention. He did not like the Reagan administration. He did not like the policies that were enacted during the Reagan administration. And in protest, he decided that he was going to burn the American flag. He was charged with desecration of the American flag, and he was ultimately convicted, sentenced to 1 year in jail, and had to pay a $2,000 fine. He appealed, and the U.S. Supreme Court decided, in the majority opinion, that if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit expression of an idea simply because society finds it offensive and disagreeable. And, in recent times, there are a lot of hot button issues now, whether abortion, whether you're for abortion or against abortion. There are also gun rights, and these are decisions that have come before the U.S. Supreme Court. And you've heard and you've seen, as a result of these opinions, there's, protesting. Sometimes, certain justices are targeted. And these are all actions as a result of opinions. But when you think about it, what role should that play as citizens? They say that, justices, Supreme Court justices, and most judges aren't elected. They're appointed. Should someone appointed have that right? But, again, as judges, we just can't let any of that affect any of our decisions. We're bound by the Constitution and the law. Next slide. I think that's it for me.
Yes, thank you. So we just heard a little bit about how it's important to make judicial decisions that may not be popular but abide by the Constitution. And now Judge Feer is going to go into greater detail about talking about impartial judicial decision making.
So much, Tori, and thank you for putting together such a great panel and a great program. And I want to thank FAU Honors College and Professor Tunick and FAU. One of my passions is speaking to students because I really think it's important for people to have a positive experience with judges before they have a negative one, especially in light of what Judge Zuckerman was saying about jury service and about coming to the courthouse and, coming and doing your civic duty. So my fun fact, at least it's fun to me, and I know this is being recorded, is that my smarter, better half, Professor Fewer, is sitting in the back. He's going to clap for himself. There you go. And he teaches here at the FAU Honors College and really enjoys it. And so let's talk a little bit about what characteristics you look for in judges. And, this slide talks about when you walk into a courtroom and you come and you see a judge, what do you expect to happen when you go and observe in court? And I'm going to ask Tori to maybe walk around a little bit with the microphone because I want to ask you all interactively what you expect to see or how you expect a judge to act when you go to a courtroom. Raise your hand. What characteristics do you expect of a judge? What makes a good judge? Otherwise, I'm going to call on Judge Reinhardt in a minute. And
I see one in the back.
anybody?
Hi, my name is Walenta. This might be a little stereotypical, but I would expect a judge to kind of be, real serious, focused, like ready to send somebody to jail. But obviously, you would want a judge that is understanding. Sorry.
That's okay.
Can you see me now?
Yes.
Obviously, you'd want a judge that seems understanding, fair, that you think would give you, a fair decision.
Those are all great points. And you mentioned serious and focused. It is a serious job. And all of us up here and all of us in the 15th Circuit take our jobs very seriously because we realize the impact that we can have on families, on children, on companies, on people who are facing prison time. So it's very important for judges to be fair and serious about the job that they're doing. Also, being good listeners. Listening to the facts and listening and being prepared to rule properly in accordance with the law. Yes.
Hello, my name's Maddie. So something that I would look for in a characteristic for a judge would be somebody who is professional, even-tempered, and has the knowledge to be able to judge properly and fairly in the court. Thank you.
Absolutely. And that is, being professional is something that's very important because when people come into a courtroom, and there are studies that we learn about at Judicial College because we all go to Judicial College yearly to learn about the new areas of the law and how the laws are changing, new statutes. We hear about studies where people go to court and they feel like they weren't heard, and yet they won their case. And even though they won, they leave the courtroom upset because they feel like they didn't get their opportunity to be heard. So it's so important for judges to listen, no matter whether it's a pro se litigant or a victim or a defendant or a corporate entity, to be able to have their day and have their opportunity. access to courts is so important. Being able to come before a judge and plead your case and be able to have access to courts and get court time and get hearing time. What else? We talked about fairness. Yes.
In my view, it would be impartiality and honesty. I think impartiality is something I would take for granted, but at the end of the day, even judges are human beings with their own views on things. And I think it's very difficult as a judge to overcome whatever preconceived notions you may have on something to truly be impartial. And honesty, I would apply it in the sense of knowing the law as a whole and applying it as is, not cherry-picking the information that you think benefits whatever it is that you're trying to advance with a given ruling.
Absolutely. And you brought up impartiality and us being human. And of course, we're human and we're not robots. And we all have our personal opinions about certain things. But those personal opinions can have no place in our rulings whatsoever. Why? Because it wouldn't be fair. It wouldn't. We have to treat everybody fairly and equally when we rule. And so if I have a personal opinion that I feel is so pervasive or overrides my ability to be fair and impartial, I will recuse myself and step off a case like that to let one of the other 53 judges to handle that case if I feel that it's so personal that I'm not able to be fair and impartial. It is so important that people feel that when they come to court, that they know that whatever personal feelings we have are not going to affect our decisions. So absolutely. Anybody else on characteristics of a judge? So we'll go to the next slide. We'll talk about some qualifications of judges. Judges have to be a member of the bar, a member of good standing of the bar, so pass the bar exam, gone to law school, pass the bar exam, and have to have been practicing for 5 years. Character and ethics, like I said, member of good standing, disciplinary record. So it's interesting. Just because you have a disciplinary record, and I'm sure this has come up before, doesn't disqualify you automatically from being a judge if you're a member of good standing, okay? So if you're a member of good standing by the bar, then I'm not sure how that would impact you one way or another. Service to the community. We look at different types of things that judges have done in the community, like have they gone and been members of the voluntary bar associations? Have they given back to their community? Have they been a member of their church or their synagogue? These are things that make the judges' experiences that they've had in the past inform them to be a good judge, right? When different people in the community come before them, different walks of life, different races, different religions, different socioeconomic backgrounds, then they're able to relate to different people when they're on the bench. Impartiality, we talked about that. Respect of colleagues, we talked about that a little bit. We talked about the process between going through being elected or being appointed, which are two different tracks. And, some of us were elected and some of us were appointed. Some of us go through an appointment process. Some of us run, but all of us serve for 6-year terms, okay? What factors should not influence judges' decisions? Let's go around, and if we have another 2 minutes, I'm sorry, I don't want to take up too much time, but what factors should not influence? We talked about this a little bit. Raise your hand. What factors should not influence judges?
Donations from PACs.
Okay, right, exactly. So judges, and that's very important. So judges cannot fundraise in any way when they're running for judge or when they can't participate in fundraisers when they actually are a judge. They cannot take a position, a political position, so they can't be involved in anything political. So that's very, very important in terms of, knowing, because if judges were going to go to fundraisers, or let's say they were going to, if they were able to go to political events, then when people came before them from maybe another different political organization, they wouldn't feel like they would have a fair shot, right? So, yes. Anybody else? What other decisions shouldn't, what other things shouldn't influence a judge's decision? Emotions, right, exactly. And we talked about the fact that judges are human. And obviously, especially in criminal court, cases are very emotional. And they're very upsetting for the defendant, the defendant's family, and the victim's family. And so there are many times, and I would hazard to guess if you ask the judges up here, that sometimes we have to take breaks and go back to our chambers and kind of, decompress and think about it and reflect, because, we can't get emotional. There's case law when, let's say, for instance, there's some case law where a victim is crying on the stand. If a judge gives a victim, a box of tissues, that could be perceived as being biased towards the victim. So it's difficult to keep our emotions in check because we realize the seriousness of the job. However, it's very important not to let our emotions influence our decisions. Anybody else? Yes.
Basically, what you're saying is that it's like best to be like not necessarily neutral to like the case, but like it's best to like not take either side.
Well, no, you absolutely have to be neutral in terms of the way that you go into it. Your decision that you make as a judge cannot be influenced by bias or any sort of personal motive. You're basically taking the facts as a judge. And when you all are jurors, because I know you're not going to throw away your jury summons after what Judge Zuckerman said, because it is your civic duty and a small price to pay for the freedoms that we have in this country. But if you, if you serve as a juror, you judge the facts. So you look at the facts, you look at the evidence, you listen to testimony, you judge credibility of witnesses, you apply those facts to the law, and then you render a fair and impartial verdict. So you absolutely have to be neutral and just take the facts that you believe are actually credible, look at the evidence, which could be documentary evidence or other type of physical evidence, and then you apply that to the law, and then that's how you come to your decision. And if you're a juror, that's how you come to your decision also. All right, turning it over.
Okay. So I know Professor Tunick wanted to, you guys all have lots of questions? Not really. Okay, good. So I don't have to rush that. All right. So good evening. I'm going to talk to you about the Constitution and voting rights. And most of you have your pocket constitutions with you. And if you were to look for the right to vote in the original articles, you might have trouble finding one. Much of the government's authority as it pertains to voting rights stems from amendments to the Constitution adopted following the Civil War and legislation passed during the Civil Rights Movement. Now, the preamble to the Constitution starts with "we the people." However, what we learn is that we the people did not really include all or most of the people. It did not include black people, women, poor people who own no property. We the people generally meant white men who were property owners. And so as our society changed, several amendments to the Constitution were ratified. In 1869, the 15th Amendment extended the right to vote to African American men. And by the way, these amendments also gave Congress and the federal government the power to enforce the amendment's protections. In 1919, the 19th Amendment gave women the right to vote. In 1962, the 24th Amendment declared that the right of citizens to vote shall not be denied by reason to pay any poll tax or other tax, thereby ensuring that wealth or lack of wealth was not a bar to voting. Finally, in 1971, the 26th Amendment prohibits the state and federal government from using age as a reason to deny the right to vote to citizens who are at least 18 years old. We got a bunch of 18-year-olds here? A few? Okay. Come on, you're only 18. You can raise your hand. It's not, all right. You know, we live in an uncertain political climate that makes it questionable how the federal government is going to protect voting rights going forward. Recently, many states have passed laws making it more difficult to vote. Changes in, requirements for mail-in ballots, location of ballot boxes, voter registration, voter identification, all will have an impact on ability to cast a vote. And we also have to be alert for gerrymandering. Anybody know what gerrymandering is? Yes, sir.
Gerrymandering is where they adjust the voting districts
Right.
to have more of one party.
There you go. It's a process in which state governments manipulate the boundaries of an electoral district, such as a minority district, to favor specific political interests. So the question becomes, what will a conservative Supreme Court do to protect voting rights and stop gerrymandering? Well, in early 2023, the U.S. Supreme Court answered that question in a case of Allen versus Milligan in a 5-4 decision. The court ruled that Alabama's redistricting their congressional map likely violated the Voting Rights Act. And as an example of why this is important, the court, instead of issuing a stay of the lower court's order, meaning putting it on hold, they allowed the redistricting to go forward while they considered the case. And as a result, in the 2022 elections allowed Republicans to win 6 of the state's 7 House seats that had previously been Democratic seats under the old redistricting map. And by the way, the use of gerrymandering applies to both parties, and it's generally determined by which party is in control at the time. But more than anything, young people who are old enough to vote and need to be actively engaged in your government, especially today. Your vote counts, as was illustrated in the 2000 presidential election between Al Gore and George Bush. The entire election came down to the state of Florida, and of the 6 million votes cast in Florida, Bush led Gore by 537 votes. So, I know like none of you were born then, which is really depressing to me.
Celebrity.
But if you look at that picture, the reason there's a guy sitting next to me. By the way, I'm the young, good-looking guy in the yellow shirt. There's a guy sitting next to me with a thick mustache. Who knows who that is? Anybody? Not you, Leonard. Yes, sir.
Is that John Bolton?
John Bolton,
Yes.
Okay? And so you've all heard the term, to the winner go the spoils, right? Bolton was there as a Republican Party member overseeing the recount. He later became UN ambassador, ambassador of the United Nations, and secretary of, National Security Advisor for President Trump. So there you go. Anyway, so as I said, the entire election came down to the state of Florida. Of the nearly 6 million votes cast, Bush led Gore by 537 votes. So in 2000, I was a new judge, 6 months on the bench, and I was put on this canvassing board to go do a very boring assignment, okay? And that was, you certify elections along with the county commissioner and supervisor of elections. Because the election was so close, less than 0.5%, a recount of all the ballots had to be conducted. First, Al Gore had requested manual recounts in only 4 counties. The problem was really these are punch cards. You used to put them in a machine and you punch holes, and if the hole, they didn't put them in right or they didn't punch the holes right, the vote never counted. So the real question is, you're looking at a punch card, how are you supposed to determine voter intent from a punch card, right? If the hole isn't punched out, what do you got? So that was really the big issue, was what standard are we going to use to count votes? The Florida Supreme Court next ordered a full state manual recount. That's when all the ballots were loaded up in rental rider trucks or something and hauled up to Tallahassee. And you guys don't remember when O.J. Simpson had that slow police chase either, but yeah, it was like big news. Let's show the rider trucks going up to Tallahassee. Anyway, so they ordered a full recount, but ultimately, in a 5-4 decision, the United States Supreme Court put a stop to Florida's recount, finding that the recount rules were vague and inconsistent, resulting in arbitrary and disparate treatment of ballots, meaning, what you may call a vote in Palm Beach County, they may not call it a vote in Broward County. So really, in that case, is sort of an unusual situation because the U.S. Supreme Court basically handed the election over to George Bush. Interestingly, Al Gore conceded, and that was the end of it, and a little different than what's going on today. However, the only way to protect your vote and ensure that your vote will be counted is to encourage massive voter turnout at elections, which can overcome most voter suppression tactics. So y'all gonna go out there and vote when you can? Got to do it, right? Okay, thank you.
Mr. Can I ask you what a hanging chad is?
No, they have no idea what
Not
that
going to talk
Or
about
a dimple.
is. You guys know what a chat is? You have no idea.
Anybody here named Chad because that
Some
became a
kids
name
name.
after? Anybody here Chad?
Maybe.
My next
Thank
door
you,
neighbor's
Judge Burton.
Chad.
Okay.
Thank you to all the panelists for your insights, and I would love to open up the floor now to question and answer if anybody would like to ask the panelists anything.
Hello. I was wondering how you guys feel about like controversial court cases being televised, like how you mentioned O.J. Simpson and like all of those serial killer or like, you know, the Menendez brothers. Like, how do you guys feel about those? Do you feel like that's a good idea, for lack of a better term, or should all cases be televised or should none?
Good question.
That's a good question.
Such a good question.
That's a really good question.
I think if it's done right, they should be televised. The problem is sometimes, you know, everybody sort of gets sucked into the camera, you know, and that causes a lot of problems in some of those cases, like O.J. Simpson or whatever. There's a lot of criticism on the judge during that case, but
And that's a very important question, especially, there's some high-profile civil cases, but normally criminal cases are very high-profile, as you mentioned. And when you're a judge, as we talked about, you really have to completely divorce yourself from any emotions or any political pressure. And, you know, as, you know, I tell my kids, and it's applicable on the bench too, sometimes the right decision is the very difficult one, and you cannot let that camera have any effect on your decision, period, end of story. And we also have certain rules about cameras in the courtroom. There can only be one camera in the courtroom. Jurors are not, you know, on camera because we want to protect their anonymity to the extent that we can. So there's definitely certain ramifications about that, but, you know, the media is entitled to cover cases, so.
I mean, there are pros and cons, I think, to everything. You certainly have positives and negatives for media and camera coverage in the courtroom. When you're talking about a positive, access to the courtroom and knowledge of the judicial system, I think, is extremely important. It's one of the reasons I like doing these events, because the more I think that individuals know about the judicial system, the more they're able to understand it and, one, appreciate it, and two, not be fearful of it, right? It's very easy, I think, to think about these vague ideas and have it be very intimidating. But really, our courtrooms are open, absent a few juvenile matters and other limited circumstances. The courtrooms are public and proceedings are public. My courtroom's open every single day. Individuals will come in and watch trials, and it's always something that I encourage. One of the cons, I think, if we're talking about the media coverage, is we can just look at the Johnny Depp trial and the snippets that were pulled and played on TikTok, right? Right? I mean, you all saw it. It was wild. There were just snippets played, and it became this huge thing. And I think it's very easy to pull a tiny little clip, whether it's the judge talking or a witness speaking or anyone else, and really either demonize them or really take it out of context. So I think it can become dangerous, as that case certainly made clear. But there's pros and cons to everything. It's one of the judge's job is to weigh public policy and freedom of the courts with the rights that a defendant has, the right that the victim has, and other parties to the proceeding.
So if I can add a little different take on that as well. The rules say that, so first of all, it's different between state and federal. So Judge Reinhart does not have cameras in his courtroom. The federal government says no cameras, or the judiciary says, and that's why you'll see sketch artists. Anything with the federal court, you'll see pictures of a sketch artist doing it. In state court, there's rules that say you must allow at least one television camera and one still photographer. The question that has arisen now is, what is a television camera? Because the rules were written before this. So I sit on a committee where we actually had to argue or develop rules about what is media. Is a media, when I started practicing was Channel 5 and Channel 7 and Channel 25 and a radio and a Palm Beach Post reporter. Now, is it somebody that's a podcaster? What is a journalist? It got so confusing that we've kind of ditched it, and the old rules still stand. So it's one television camera, and you think about that one that sits on the shoulder and somebody's trying to get in your face. It's not this. So the judges then, going back to interpreting, they have to start saying, well, what is that? What is a camera? The other thing I just want to say, and I think I did this for extra credit, or this was one of my assignments, when I was teaching here, and I would harp on what I think it was either Judge Feer or Judge Zuckerman said, watch the court. Go down, courts are open. I would highly recommend, there's the Palm Beach Gardens Courthouse. There's no jury trials there. You can go down to West Palm Beach, but go watch court. It is fascinating. And if you sit on a jury, it's fascinating. I sat on one, and I was elected foreperson, although I didn't want to be, and I deliberately tried to sit myself away. It was fantastic. So I would do not skirt that. I would highly recommend doing it.
It's true. I mean, we get questionnaires back after people have served on jury service, and literally they say, I've heard about this since elementary school. I've never served. I'm honored to be a part of the judicial system. I'm honored to be a part of the justice system. No matter which side wins, no matter what happens, it's truly an honor for them to see it, whether, because most people, even lawyers, most lawyers are not litigators. So, there's some lawyers who never see the inside of a courtroom either. So I highly, recommend that you participate in your civic duty and come to jury service and see it. And most people, and what's an integral part, I think, back to jury service, and we all talk about this because it impacts cases being moved and marshaled to finality, is that most of the cases just are settled and resolved by the jurors being there, by the jurors appearing and standing at the door before they come into court. That resolves cases. I had a friend who came to jury duty the other day. She was there all day. She enjoyed the process, and she said, you know what, at 4 o'clock the case settled, we got to go home. So she had a good experience. Anyway.
Anybody else questions?
Hi, my name is Katarina. So I was wondering if any of the judges here today are familiar with the case of Rodney Mayo versus City of West Palm Beach and James Keith, as I was one of the interns on Rodney Mayo's campaign, and I still work for the City of West Palm Beach. And there was a lot of talk around it, specifically in the city and among the 500 block. And I was just wondering, what are your thoughts? And specifically, how can we make municipal elections more appealing to people aged 19 from 24, as in the previous election, there was only about 100 people who voted from that age group?
Do you want me to be your attorney? Do you want to answer?
What's it?
So if I can say, so
I used to go to his bars.
what I would say, since I used to work at the court, is they can't answer regarding the specifics of the case, but with regard to, sorry, I have to speak for, I'm trying to speak for you guys. But with regard to how do you encourage people who are 18 to vote, that's a different question.
Yep.
So,
Yeah, I mean, obviously, we can't comment about a case, and I don't think that was any of our cases. I remember hearing about it, but
Right.
I don't know a lot about it. But I do think that it's important to get people to vote. I do think it's important to get young people engaged, and I think someone like you could get people registered to vote and get people more interested, just even in your own college, here at FAU Honors College. And I'm sure all of you, are already registered to vote. But doing things within your community to get people to vote and understand why voting is important. Because I think that's really where people don't understand how their vote makes a difference. And they need to understand, the people that are elected to their school board, the people that are elected to their city government, they affect their roads, they affect their streets, they affect their schools, all of those things.
You guys, I assume, talk politics, you have opinions on everything going on in the world. So the key is, how do you take, the talk, and then it comes to election day and nobody feels like going or whatever, or it's pouring out or what. I mean, The idea of showing you Bush v. Gore was that very reason.
500
Because
words.
it matters, and votes count, and you got to get out there, because you can make a difference in what happens. It's your government, you know, it's your society, and if everybody just talks and then does nothing about it, you know, that's the problem.
And
So,
it's not even like back in the day where you would have to wait in lines all day. I mean, you can absentee ballot if you want, and you can do mail-in ballot. You can do early voting. I mean, I think you mentioned a bunch of those things. There's so many things you can do. I mean, it used to be like my parents would wait in line for like 6 hours. They'd have to take a day off work, and, you know, the lines would be around the corner, and I would go with them. And, you know, it's so easy now to actually go and cast your ballot.
even in city elections, so. Anyway.
Thank you.
Hi, my name is Walinta. I wanted to ask, has there been any cases that you all have decided on in which you ended up regretting in terms of like it went against your own personal beliefs, but you knew that you had to be impartial? I'm sorry for leaving you confused.
No, that's okay. So when I've been in the criminal division, I've been in the civil division, now I'm in the probate division, and I was in probate with family previously. In the civil division, and I'm just going to speak generally, it's not going to be the exact answer I think you want, but in the civil division, things generally can be reversed. They can be changed. You can go back if you feel like you made a mistake. In the criminal division, it's much more difficult to do that. So, which is why it kind of goes back to what I said. When you make a decision, and, you know, I think all the judges would agree that especially sentencing is the hardest part of our job, and it's difficult to reverse. And so that's why when we make decisions, we take breaks, we do research, we ask for help. But there are mechanisms where if we think we made a mistake to reverse ourselves. And there's also an appellate court above us, as was talked about earlier, that will tell us if we did something wrong, which is important.
And I can tell you now, being in the county civil division, and I deal a lot with evictions. So I have a lot of the litigants that come before me are pro se, meaning that they don't have an attorney they're representing themselves. And so the eviction law is very, very clear, and certain things have to be done, and if XYZ isn't done, then, you know, the person is going to be evicted. So I get letters from litigants telling me that, you know, if we evict them, they'll be homeless. Their children go to local schools, and let me stay longer. And those are very difficult decisions. I follow the law and I make the decision, but doesn't mean that after I do it, I'm not sitting in my chambers thinking, oh, I feel so bad for this person that's potentially going to be evicted. And so those are decisions that I'm dealing with every day, and so they're difficult, and but it's something that I signed up for, and that's why I do it every day.
And I think it's important that for judges, if they realize they made a mistake, to go and correct, to do everything that we can to correct if we realize that we feel like we erred.
Thank you. In the interest of time, we probably have time for one or two more questions.
How, as a judge, do you go about deciding, not whether you would be for or against something, but do you go about deciding a high-profile case with massive political repercussions and with also massive political pressure from both sides? And that's especially been the case with a whole lot of new Supreme Court cases. Not that you would be for one ruling or the other, but how would you go about deciding something with massive political repercussions and from demanding pressure from both sides and trying to stay impartial in that kind of sphere?
That's a great question. I mean, listen, I think if you're on the bench, you run into those situations occasionally, maybe not massive, but listen, you signed up for this job, you got to do the job. That's the bottom line. And it may go against what I believe. It may go against what I think. That's the job. You have to try and do it. If you're a judge making decisions because, whatever, some political pressure that you think, then you're not doing your job. Then you shouldn't be a judge because, that's the job. You have to make those hard decisions sometimes.
It's true. You took an oath to do it, and this is why you have to, and this is kind of a different topic, but keep yourself mentally healthy. Keep your, work out. Make sure you spend time with your family. Make sure that you don't get so entrenched in a case that you're not able to relax and that you might bow to pressure, because it's absolutely, of the utmost importance to be fair and impartial. And, like Judge Burton said, you signed up to do the job, and we make decisions that are unpopular, and that's the job.
Let me just say real quick, so when I was doing that election recount back in 2000, before you all were born, granted, I wasn't sitting as a judge, as on the canvassing board, looking at ballots, but cases were going on in court, and the cases would go to circuit judges, and, oh, wait a minute, I got a bush in my backyard, I'm recusing myself, and I'm sitting there like the new county judge going through all this, and they're all bailing, all recusing for whatever reason, so that was very frustrating. But anyway, I'm not going to name them.
Thank you. I think one more question, and then I think we're...
So I think I have the last question, and they've all been such great questions, and mine is so petty, so I'm very sorry about that. But Ms. Sportman, you mentioned when you were giving your opening speech about the importance of judicial interpretation in legislative statutes. And I agree with you, but I thought that it was a little bit unclear what you were saying. So if you don't mind, I want to ask a clarifying question. Why interpret legislative texts? Some judges are strict textualists, and of course they still interpret legislative texts, but why would you do that? Take the driving in the park example. The legislature that passed that law, it didn't cease to exist. It didn't hand off the law to the courts and then just go into the ether. So what would be a compelling reason not just to take that text literally, to throw everyone in jail, and let the legislature clarify that law if it wasn't what they intended?
So I think, and I missed which law you were referring to, but
you gave it a hypothetical.
my example. I'm sorry, my example. So if you can read it and it's clear, and there's case law with this, and I would defer to the judges on this, if you can tell on the face of the statute what it means, then by all means you are following that. But you are called upon sometimes to answer the question because it can be interpreted or you don't understand it. So there are no vehicles in the park. What is a vehicle? Is a vehicle, because 5 people got tickets. So the legislature is clear. Like if I drove my Volvo into there and I'm just a guest, it is clear there's no need for interpretation. But when a sanitation worker drives their truck in, is that a vehicle?
What is the distinction there? Why wouldn't it be?
If you can, and I don't know if you all know it off the top of your head. If it's clear and you can find it from the text, there is no more interpretation. You're following that. But if it's unclear,
I guess I'm saying, what is that distinction between the sanitation worker and the person who drives the Volvo, besides the fact that maybe it feels wrong to you?
Well, because there's garbage overflowing, and they have to empty the dumpster that's inside the park. And a bicycle. So is a vehicle. Yeah. So I'm riding my bicycle.
I guess my question is, why would that be the role of the judiciary to clarify that and not the legislature? They could amend the law.
Right. So you have a criminal case before Judge Zuckerman, and the person is facing a $100 fine for driving their bicycle through the park. Now, a bicycle that has a motor on it, is that a vehicle? So you would look at case law to determine, does adding that motor to a bicycle convert it to a vehicle? What is a vehicle? What is the definition of a vehicle? Is it something that's being propelled by something other than your own feet? So again, if somebody's being charged with something, you read the statute. If it's clear on its face, absolutely, you don't need to go further. But if it's unclear, because somebody's now charged with a crime, there may be some interpretation. And then you have a case that from Nebraska that says a propelled, or I shouldn't say Nebraska, from Tampa that says a bicycle that's propelled by a motor is a vehicle. And yet in Jacksonville, a court said it's not. So now you have to interpret it because you have different decisions. So I hope I answered that question.
I understand that. If you don't mind me just asking one more follow-up, what would the lack of clarity regarding a sanitation truck be?
Because you're doing your job. So did the legislature intend to prohibit a vehicle that is
required to go in the park to empty the garbage, because how else is the garbage going to be emptied?
Can I just close maybe the
Absolutely.
question by adding one more thing? And I think I spoke about this a little bit as well, and there are certainly different viewpoints that I will not and do not want to get into. At least when I spoke about interpreting perhaps statutes, there was rude, right? We talked about that a little bit. The reason that comes up isn't because I'm sitting at my desk and I think, I would like to challenge a law, right? So I pull the law and I look at it and I say, what here can be challenged? That's not the case. The reason that would come up is because, for example, I have a case in front of me. There is a challenge by the defense about whether that law applies to their client. And that's sort of when you get into what I was talking about earlier, which is looking at case law, the definitions provided in the statute, or other authorities to make the decision that needs to be made, right? So I think when we talk about it, it's not because you're cherry picking a case or it's just randomly coming up with the law. It's because facts are presented, and as Ms. Borman said, you're doing your job in having to make a decision on perhaps a motion to suppress or a motion to dismiss based upon the facts that are presented in their own particular case. So that may be when it comes up, if that helps.
Thank you all for your questions and your participation, and thank you again to our panelists for volunteering their time tonight. If we can give them a round of applause.